Before that, here's Clive Anderson with the programme which explores the legal issues of the day.
Hello and welcome to Unreliable Evidence. Now, with the winding down of operations in Iraq and now Afghanistan, British armed forces have for the moment more or less stepped away from the battlefield, but are still coming under fire in the courtroom. In a series of cases in the High Court, the Supreme Court and the European Court of Human Rights in Strasbourg, it's become increasingly possible for soldiers, British and non-British citizens, to sue the Ministry of Defence for matters formerly covered by combat immunity. Soldiers injured in battle or the families of those killed in action can now sue the MOD for negligence or for the breach of their human rights. Will the introduction of human rights and the law of negligence into the theatre of war substantially undermine the effectiveness of the military? The think tank Policy Exchange, in its recent report Clearing the Fog of Law, says the judiciary is the wrong body to hold the army to account, retrospectively examining purchasing, training and combat decisions, and warns that almost any conceivable future action by the military could be challenged in court. But shouldn't the law apply to everyone, everywhere? And more fundamentally, who should govern the military, the generals, the government or the judiciary? Is the courtroom the right place to judge life and death decisions made in the heat of battle? To battle this out, I'm joined by Dr. Jonathan Morgan, Director of Studies and Lecturer in Law at Corpus Christi, Cambridge, and co-author of the Policy Exchange report I've just mentioned. Andrew Buckham, who served with Army Legal Services in Bosnia and Kosovo, and who now works with the solicitors Irwin Mitchell's Specialist Armed Forces Claims Team. Jessica Seymour, QC, leading counsel who specialises in human rights and public law, who's acted for a wide range of clients, including the relatives of a soldier killed in action in the landmark case of Smith and the MOD. And down the line from Edinburgh, the Lord Hope of Craighead, who recently retired from the Supreme Court bench and who presided in the Smith and MOD case, the decision central to our discussions in this programme. So, now, in the wake of some of these cases, the House of Commons Defence Committee released a report warning about what it described the judicialisation of war. Now, Dr. Morgan, is that what you think is happening?
Yes.
The judges are taking over?
Yes, that's right. So Policy Exchange has produced two reports on this in the last few years. The first seeks to establish the impact that these legal changes are having on the military, and the second, which was published last month, suggests that remedies that could be provided to stop it from happening.
Jessica Seymour, would you agree with that, or is it the judicialisation of the whole world that's happening?
Possibly. What's quite interesting about the Policy Exchange report is actually the language it uses, because it says that the judiciary is pioneering a revolution in military affairs, that it's the overbearing judicial power, it's judicial imperialism, and it threatens the balance of powers in our constitution and the fighting capacity of our armed services. So I question really the motivation behind that kind of language.
All right, so you're going almost to an ad hominem attack before we even get going on the general principles. True to your skill as an advocate, clearly. So, Andrew Buckham, just concentrate on this judicialisation. Do you think that's an identifiable issue? You may use another term, I don't know, but that the whole area of what's going on in the military situation is coming under the purview of the judges?
I think members of the armed forces do have some concerns about this. They're worried about individual reputation. They're worried about the reputation of the armed forces. Perhaps, though, in terms of looking at these issues in more closely and more under the microscope, I think there's some misunderstanding in relation to the law and the effect that it has on the armed forces. And while the debate is very much welcome, I've also read some of these papers and obviously had a look at this, and some of the wide sweeping reforms and recommendations don't sit comfortably, I have to say.
I see. The recommendations in the report. Let me just bring in Lord Hope, since he is or was a judge. The query is that perhaps judges in this area have been given too much power to supervise things which might be outside your experience, decisions made on the battlefield or so forth. Did you worry about that in deciding this and other cases?
I think you have to remember that judges only deal with the cases that are brought before them by other people. It's people like Jessica who think up grounds for bringing claims, and if claims are brought, the judges have to deal with them. I think the sort of suggestion that's coming through that the judges are asserting a jurisdiction on their own is quite misconceived.
So if you're getting more power, it's not your fault. You've been asked to take a decision.
Well, we live in a country where the courts are available, and the judge's job is to deal with the cases as best they can. And it's sometimes said that the judges are not fit to take decisions in matters affecting combat, but we may come back to that. But, of course, judges decide cases on the evidence and the arguments put before them.
Yeah, Jonathan Morgan, that's a sort of fundamental issue there. Judges don't know anything about how to do brain surgery or how to drive a car at speed around a racetrack. But if there becomes a legal dispute about misbehaviour, negligence, crime or whatever, somebody has to take the ultimate decision. That's usually a judge, isn't it?
Well, I don't think anyone's suggesting the Supreme Court, when a case comes before it, should say, well, we're not just going to answer the question, but how should they answer it? The dissenting judges, there were 3 dissenting judgments or 3 dissenting judges in Smith and Ministry of Defence.
So it's 4-3 decision.
It was a narrow 4-3 decision.
So a knife-edge kind of decision.
Exactly. And the dissenting judges thought that there should not be liability on the facts and would have dismissed the claim.
Let's find out what happened and what were the facts of the Smith case. If you could deal with that, Jessica Seymour.
Very briefly, there were actually 2 Smith cases, very confusing. The Catherine Smith case, where there was a soldier who died of heat illness, and there was an inquest, and the question arose as to whether the Human Rights Act extended to that soldier operating overseas. And the case was successful up to the Supreme Court, and then the Supreme Court said, no, the jurisdiction of the Human Rights Act is only within the territory of the United Kingdom.
And the other Smith case?
That was 2 years later. There was another Smith case which concerned military equipment decisions, including snatch Land Rovers. And in that case, the government sought to strike the claim out on the basis of combat immunity and also no jurisdiction under the Human Rights Act, and they lost on both heads.
All right, now you're raising lots of terms there that I just want to go. So, snatch Land Rover case. Let's bring you at this point, Andrew Buckham. I think people will vaguely remember things to do with Land Rover. What was wrong with the Land Rovers in that case?
What they were saying is that it was an old piece of equipment, and it wasn't adequate for the operational theatre that it was deployed to.
So it was being blown up. It wasn't as reinforced as more modern or stronger vehicles were. So the question then ranged over whether who bought the Land Rovers, who decided to deploy them, who used them on sort of a battlefield situation.
That's right.
And
there was another case.
Yes, thank you, Lord Hope.
Came before us, if I can.
Yes,
add
please.
What Jessica Seymour said, and it wasn't her case. It was a friendly fire incident where a tank, one of our tanks, fired on one of our other tanks, mistaking it for an enemy tank. And the people who brought that claim were very careful not to blame the tank commander for having fired that shot. It was about things done about equipping the tanks with proper recognition equipment and so on before they set out on their operations.
All right, so
it raised an issue about combat immunity in that situation, which was rather different from the situation about the snatch Land Rovers.
All right, so you've established the sort of facts that lay behind these cases. There's the possibility the wrong equipment was there, the wrong training in relation to what ends up as friendly fire. Some of these decisions have been made in England or in Britain 10 years before. Some are being made on the ground in the course of the battle. Those are the sort of issues that have to be covered. But I just want to pause before you get really stuck into this. And you've mentioned combat immunity. So what is combat immunity? Perhaps I'll ask Dr. Jonathan Morgan to explain what that is.
Well, the leading case there, the case of Mulcahy, which was decided in 1996, and this arose out of the first Gulf War, in which the claimant there was injured when, well, as he alleged, a gun was negligently fired and it damaged his hearing. So he sued the Ministry of Defence, arguing that the commander of the gun had been negligent and that they should answer for that negligence and pay him damages. But the Court of Appeal said that there's simply no duty of care owed between two soldiers on the battlefield in a situation like that.
All right, so Andrew Buckham, you bring cases on behalf of, nowadays, you bring cases on behalf of soldiers who've suffered injury or on behalf of their survivors if they've died. So combat immunity would defeat your claims in many circumstances if it was still held to be the law.
It would. I mean, decisions that are made in the heat of battle, in terms of a commander making a decision on the ground in relation to his troops and equipment, that would fall under combat immunity, and quite rightly so, because a commander shouldn't have to worry about negligence, Human Rights Act issues by making those decisions.
Yeah.
So the Smith case hasn't changed that. That still exists. So the commander on the ground or the soldier is protected by combat immunity when they make those decisions and follow those particular actions.
So what if the commander on the ground decides he'll use a snatch Land Rover in the particular circumstances faced by him and his men, and the Land Rover gets blown up? What was the wrong decision? The commander on the ground?
It's not the commander on the ground.
Or the purchasing clerk or the purchasing minister in 1998?
Well, this is where I think commanders may have a slight misunderstanding in relation to the law, and they have worries, is that they sometimes worry they would be held individually for those decisions, and they're not. They're protected by combat immunity. Mm. What perhaps is more interesting is when you're looking at those type of equipment or procurement issues, particularly in Whitehall or particularly in relation to a longer term procurement as to whether the MOD should be held liable, particularly where, for example, there are failures to address obvious shortcomings in regards to the equipment.
I think if I may interrupt.
Yes, Lord Hope, yeah.
There, if you forgive me, the Challenger cases, the friendly fire ones, are a very good example of that because, as I said a moment or two ago, the commander on the ground was not being criticised, and the court's decision made it clear he couldn't be criticised for his decision. What they were dealing with was equipment and training pre-theatre or on arrival at theatre before the operations began, when there was time to think and sort things out. And that isn't combat, and therefore the immunity doesn't apply to it.
So, Dr. Jonathan Morgan, if something's been done negligently in an office in Whitehall, are you saying it shouldn't be possible to bring a case of negligence simply because it's the Ministry of Defence? Or do you not criticise that area of the law?
I would criticise it, although for a different reason than one would criticise the earlier case of decisions taken in the heat of battle. There's a different problem, which is it drags the courts into political waters, I think, to start having to review whether decisions taken about what kind of equipment to procure was negligent or not. It's a point that was made by Lord Roger in an earlier case. He said, well, whenever someone is injured in battle, it's perhaps always possible to say that had they been better protected or had different orders been given or had the strategy been different, that they would not have been injured or killed. But very often it gets the courts into political matters. And I would argue that here it's important for the Ministry of Defence to be accountable to Parliament and through Parliament to the people. That we're not saying that the Ministry shouldn't answer for these mistakes if they've been made, but it ought to be done through the political process rather than challenged by the courts.
And what form would that political process take? That in a general election we might vote against a government because the purchasing done under their watch might have we criticise? It's not really the issue that normally decides an election, is it?
Well, that is true, of course, but ministers are accountable for their decisions and responsible ultimately for the decisions taken by the generals and so forth. For example, questions on the floor of the House of Commons or to the Defence Select Committee of the House of Commons, so that there is an ongoing scrutiny by MPs of these kinds of decisions.
What do you say to that, Jessica Simon? Because I think you've been quite a participant in the development of this area of the law.
To say that Parliament is an effective means to scrutinise decision-making or deaths or injuries seems to me to be totally wrong. Courts actually look at evidence, they look at facts, and at the end of the day they may come and say, you know what, the military did a good job here, everything was fine, and the claimant loses. But that process in itself serves a function which, can be improving what happens next time, etc. But to suggest that a mother of a dead soldier can get any kind of proper scrutiny or review of actually what happened through Parliament is nonsense.
Well, let's just look at it from the military's point of view and their criticism of this. Because speaking in the House of Lords after the Supreme Court ruled that the government had a legal duty of care to protect its soldiers and their human rights, former First Sea Lord Lord West had this to say.
My lords, 31 years ago, my ship was bombed and sunk close inshore in the Falkland Islands during the amphibious landings, and its AA weapon systems were totally inadequate in the position it was placed in. I knew that as the commanding officer. My task group commander knew that. But it is the duty of military men to fight the war they're in with the equipment they have. It is clearly a total nonsense that one can use human rights legislation to go against that. And indeed, if we had not done that, we would not have won that war. Would the noble Lord the Minister not agree that this is totally bonkers, applying this sort of legislation to war?
Well, Lord Hope, I don't know if Lord West is calling you bonkers or your decision bonkers, but you see the point he's making. War is a dynamic, brave, sometimes even foolhardy situation, coming along looking at it from we haven't really mentioned human rights so much, but to negligence and human rights point of view, can look odd to a military man.
I've great admiration for Lord West, and he's a very fine naval officer, and I've every sympathy with the point that he makes. But I don't think Smith is dealing with that situation. At least the legal framework is framed isn't for a moment questioning the kind of action that he took or his others in his area were taking with the equipment that they had. What the argument is about is the people who took the decisions about the provision of the equipment. But if I can go back to a point that was mentioned a little earlier, one of the paragraphs in the Smith case does make the point that great care has to be taken if the issue is one related to political judgment or issues of policy. And one can understand that in an urgent situation like the Falklands, people have to go out with the equipment we've got because they have to get there and deal with the urgent situation. So I think the law is sufficiently sensible to deal with the kind of point that Lord West was making. And I have a feeling that he rather overreacted to the Smith decision in what he said.
Well, what do you say to this, Andrew Buckham? Soldiers, sailors, they go to war, sometimes in a rush with whatever equipment it is. The worry, I think, coming through from Lord West is then, I don't know if I should call lawyers, ambulance chasers, but, field ambulance chasers coming along and saying, oh, that was wrong there. Look, we lost 10 men there. That could have been better. That's clearly coming through. He as a military man, is saying we do our best in the circumstances.
They do, and the military, do get on with it and do a good job. But I think that has to be balanced by, the MOD being accountable. So, a point that was made earlier in relation to the political process to make the MOD accountable. I was part of the legal team that represented the 14 families in relation to the Nimrod inquest.
But you better just explain what the Nimrod case was about. Well,
this goes back to an accident in September 2006 in Afghanistan where a Nimrod aircraft exploded. And following the inquest, there was then an independent inquiry by Haddon Cave. And they looked at the Nimrod fleet and they found that the actual design and maintenance of the Nimrod fleet was at fault. And this went back years and years and years and years. And it wasn't the decision to actually deploy the aircraft into the operational theatre. It was the fact that there was a long history of the fact that the MOD hadn't rectified this particular fault. And quite rightly, the families wanted to make the MOD accountable. And quite rightly, they wanted to ensure that the accident didn't happen again.
So, Jonathan Morgan, do you accept that point? You're not looking at daring do on the battlefield. You're looking at something going on in Whitehall.
Well, I've already accepted that, and I have to say I agree with Lord Hope's point that Lord Hope, who gave the judgment in the Smith case, is very careful to say that courts must enter this sort of area very cautiously. I mean, the point that divides us is actually a fairly narrow one, I think, which is whether they should enter it at all. And I would argue that they shouldn't, because even if the judges enter these fields with due caution, they're still overstepping their constitutional boundaries. So,
well, I'm not sure about your constitutional boundaries point, but are you saying that there is a role for combat immunity which should be clearly defined or expanded? Is that essentially what you're saying?
One of the dissenting judges made the point quite nicely, I think. This was Lord Carnworth. He talked about the claims being on the horns of a dilemma. He said, if the claim is pleaded in such a way that we look at the mistake that was made on the ground, for example, the friendly fire incident when the tank was fired, he said, well, the problem there is it gets into the heat of the battle type of negligence where nobody thinks that the claim should succeed. But if we go as it were, up the chain towards the decisions that were taken in Whitehall, perhaps not to fit tanks with a certain kind of vehicle recognition software, then we are getting into issues of, and I am going to stress it, of political nature, because how much money do we spend on the defence budget to core? I mean, should we spend more on defence and less on the universities? And once we've allocated the defence budget, how much of it should be spent on armour as opposed to aircraft carriers? I hope this isn't too much off topic, but there are a number of reasons why body armour perhaps was not supplied in the Iraq War from the outset. And it's not to do necessarily with penny pinching, which has often been the accusation. For example, that the procurement officers, Lord Stirrup at the time, said it would have signalled the inevitability of war in Iraq had the MOD gone out and purchased half a million armoured uniforms, yes. and that's why they didn't do it.
All right, what do you say to that, Jessica Seymour, then? You've got something that's gone wrong. Somebody's injured, somebody's killed. You can look at 10 years' worth of decisions that have led to that. Political decisions about the budget, the commander's decision on the ground. We're all sort of saying, well, you can't really query a commander's decision, but is it right that you go back and look at a purchasing decision with body armour, Land Rover, Nimrod, whichever it is?
Well, I'm going to give the very irritating answer that it all depends, and that's
all depends on the facts.
It all depends, and that's the great challenge, I assume, of being a judge, is that you have to face all those questions and work out how you're going to answer them, and these questions will be developed and answered. And obviously, Lord Hope has said that great care needs to be taken in relation to this. But can I just stray slightly in relation to combat immunity, because in the context of Lord West's statement, it's quite interesting to reflect on the fact that after the Falklands in 1987, Parliament took the decision to lift the immunity for the military against negligence. So, ironically, the situation that Lord West explains, Parliament actually decided that at that point people should be able to sue. And one has to ask why in 87 Parliament thought it was appropriate to allow soldiers to sue the military when before that they were not allowed to.
All right, so Jonathan Morgan,
I've read the parliamentary debates in the House of Commons in 1987, and the thing that clearly comes across is that the military pensions that were available to servicemen injured in, the Falklands or any other conflict had, by 1987, become extremely low in comparison to tort damages, and a very effective campaign was mounted, therefore, to allow service families to be able to sue. Just to pick up on the 1987 legislation, it's interesting that although, as has quite correctly been said, Parliament then abolished the Crown immunity that had previously applied to the armed forces.
That meant you couldn't sue them because of the special immunity of the Crown, or the government,
There was special immunity of the Crown at common law. That was removed in 1947, except for claims by soldiers against the armed forces. So it was expressly preserved in 1947, Section 10 of the Crown Proceedings Act, and that's what was abolished in 1987. However...
And is that what you're essentially complaining about?
Parliament in 1987 gave a power to the Secretary of State to revive immunity from suit and negligence in respect of warlike operations overseas. And that's actually what the Policy Exchange Report has suggested now, that this power should be exercised by the Secretary of State to prevent these negligence claims from being brought.
All right, well, this is Unreliable Evidence. I'm discussing the law and war with Lord Hope, Dr. Jonathan Morgan, Andrew Buckham and Jessica Seymour, QC. I suppose we've mostly been talking about negligence claims, but before I go on to some more general talk about human rights, I think one solution you put in your report is that why are we having negligence claims in relation to casualties on the battlefield? Shouldn't all soldiers be looked after anyway, whether you can establish negligence or whatever, a sort of no-fault compensation scheme, which some people argue should apply to the world generally. But is that one of your propositions, that we should just revive a compensation scheme?
Well, there already is the Armed Forces Compensation Scheme, which compensates any service personnel who are injured in the course of their duties. And it doesn't discriminate between those who are injured on active duty and otherwise. And it certainly doesn't discriminate between those who are injured owing to the fault of the Ministry of Defence and otherwise.
All right, and Andrew Buckham, what's wrong with that as a way of resolving this? Is every soldier puts his life on line. Sometimes it'll be his it is bad luck. Sometimes it'll be somebody's fault. Sometimes it'll require 10 years of argument, eventually with Lord Hope deciding it. But if somebody's lost their leg or something, they just need some compensation for that.
Well, the Armed Forces Compensation Scheme does provide an element of monetary compensation to injured service personnel, but it's limited in terms of what it can actually provide in regards to paying for example, it doesn't pay for adapted accommodation, it doesn't pay for care packages, it doesn't pay for future therapy. So
wouldn't that be a better way of addressing it, to improve that scheme, rather than a lot of lawyers arguing about specific cases where you can get a huge payout and others don't get anything because you can't establish negligence or breach of the Human Rights Act in relation to something that's gone on?
In an ideal world, Clive, yes. However, the Armed Forces Compensation Scheme is administered by a government agency, the Veterans UK, and they just don't have, in my view, the expertise and experience to properly quantify those type of claims to ensure that soldiers get the right compensation for what they need.
That's always the criticism of these no-fault things. You don't get the real size of your damages that you get from a courtroom from a scheme. As
my good faith was challenged at the start of this programme, I want to proclaim myself as an idealist, at least on this particular issue, because what we've suggested that if soldiers' right to bring negligence claims in respect of warlike operations overseas, if that is indeed removed, then full tort-level compensation should be paid by the Ministry of Defence.
Isn't there a gap, though? I think I'm right in saying that the Armed Forces Compensation Scheme doesn't compensate the relatives of the deceased. Am I right about that?
I'm turning to my legal experts here. Can relatives get compensation under this scheme?
I think in terms of things like a widow's pension, there is an opportunity there. But again, it's very limited in terms of what it can provide. And I think that's one of the big things here, is that if we make these quite wide-sweeping changes in terms of bringing crown immunity back, injured soldiers and their families are going to be extremely disadvantaged by that.
They would be disadvantaged if the crown immunity were brought back and the Armed Forces Compensation Scheme remained as it is. So what the report that I co-authored has proposed is a linked pair of proposals there. I mean, I personally would be extremely uncomfortable if the right to sue were removed and the Armed Forces Compensation Scheme were not enhanced as a result. So the idea behind the proposals is not to save money for the Ministry of Defence. It's to stop the courts from trespassing beyond their proper boundaries, as I see them.
Jessica Simon, I just want to ask you about the Human Rights Act and how that has borne to bear on soldiers and also non-combatants getting involved in military action or being the victims of it. Could you just characterise how that has worked in the court?
It's now clear that the Human Rights Act extends outside the United Kingdom to the British military, but also that it extends to individuals who are under the authority and control of the British military.
So somebody taken prisoner who is tortured or who loses his life, he can, or an action can be brought on his behalf because of a breach of human rights.
Yes, and the more complicated and difficult aspect of that is the meaning of authority and control, which, following the judgment in Al-Skaney, has been extended to cover effectively a shooting.
So, Al-Skaney, perhaps you just give us the facts of that case so we know what we're talking about.
I can't give you all the facts in detail because I think there are 6 or 7 applicants in that case. Each had a different fact. Some, I believe...
Where was it? It was
in Iraq.
In Iraq, yeah.
And some of these individuals, non-combatants, were shot at. I believe there may have been a detention case as well. But what it effectively established is that if you shoot someone within your authority and control, there is jurisdiction over that individual.
Right, so that means the European Convention would apply because they're in effect under the control of the British troops, British authorities.
Well, up until that point, within the United Kingdom, it had been successfully argued that the convention or jurisdiction under the convention only extended to territories or bits of territory. They could be an army camp overseas, but didn't extend outside of those territories. In fact, there is a 1975 Strasbourg decision relating to Cyprus, which makes it clear that state agent authority and control does extend jurisdiction, and Al-Skaney just confirmed that.
But I suppose it's slightly odd to be thinking about a right to life when we're discussing the battlefield situation, when the people are engaged in killing each other.
In relation to that, there is a provision in the Convention, Article 15, which allows states to derogate from the Convention, including the right to life, in a war context or emergency threatening the safety of the nation. So, in fact, the Convention itself envisages that states would go to war and people would die, and the state would have derogated, and therefore that provision would not apply. But the United Kingdom did not derogate when it went to war in Iraq.
Mm. But anyway, you Dr. Jonathan Morgan, what your proposals in your report was, first of all, the government should derogate from the European Convention on Human Rights for future overseas armed conflicts generally.
Yeah,
that's what you say.
Perhaps I could explain the reason for that, and in fact it's just been touched on, which is we argue that international humanitarian law, and for those who don't know, this is the Geneva Conventions governing the conduct of armed warfare, that these ought to be the way that wars are regulated, not the European Convention on Human Rights. And the reason for that is fairly straightforward, which is that the Geneva Conventions were drafted precisely in order to bring human rights, that's to say humanitarian concerns, into warfare, whereas the European Convention was drafted as a very, very general instrument. And it's only now, by means of judicial interpretation, being brought into the sphere of warfare. And I'm just not sure, however well-intentioned it is, I'm not sure it's ultimately very helpful to have two different layers of regulation.
Well, let me get Lord Hope's view on that. You obviously hear the point that the Geneva Convention is a better structure for looking at this rather than trying to apply a European Convention to a military situation. What do you say to that, Lord Hope?
Well, there's a lot to be said for that. When we were looking at Smith, the part of the case that troubled all of us, although we were ultimately unanimous, was the extension of jurisdiction of the Convention to areas outside the Council of Europe territories. That's one of the things that has caused so much difficulty. But the trouble is one has to live with that now. And as judges, we have to make the best of what there is before us.
Overall, Jonathan and Morgan, what are you? I'm not so suggesting you want to turn the clock back, but is it the opinion that you have or the military have? It was better if things were decided by court-martials, decided by the army or the navy or whatever. Keep the judges out. Have immunity from these various claims in a declared war or a warlike situation?
Well, in a word, yes, that's right. I mean, although I'd supplement that by saying that it's the Geneva Conventions and international humanitarian law which must be the prime means of governing what goes on in warfare. They do their best to bring humanity to bear in the situation of war. A war that is conducted in line with the Geneva Conventions is still absolute hell and full of human misery. It's not by any means perfect, but I think probably it's practically the best that we can do. And trying to be too idealistic about it, which human rights I fear threatens to be, I think it will be probably won't work, and it might even undermine the Geneva.
Well, you said you were an idealist yourself, but we've heard from a qualified idealist. But we've heard from Lord West, who it sounded as though he wasn't happy at all. Is that a general view within the military, within the generals, in fact, and the admirals and so forth?
Yes, I mean there have been a number of interventions from senior, always as you'd expect, retired military figures, saying precisely this, that they think it's gone too far, that they've detected a risk-averse attitude coming into the attitudes of junior commanders in the field now. And it is true that when you're actually on the battlefield, you can't be sued for negligence. And if you are sued for negligence, the ministry pays, not you personally. But what people are worried about is not being asked to pay damages, but is being cross-examined in a court of law 10 years later and having their split-second decisions picked over.
So I sat next to a very brave battalion commander at a conference organised by the Policy Exchange, and his comment was that he wasn't concerned with legal liability in practice in the kind of operations he was conducting. It was a risk to the men's personal safety that was in his mind, not what the law was going to say. So I wonder how true it is that what the very senior officers are saying really applies to the junior people on the ground who are actually face to face with these very difficult decisions and have to take them in a split second for their own safety and their men's safety.
Well, bringing cases like this in any sphere, there's the question of compensation for somebody who's had wrong done to them, but there's the hope that it will make things better in the future, better decision will be taken. So, Andrew Buckham, do you think that having the application of human rights, negligence, whatever, is that going to improve the behaviour of soldiers on the ground, the ministry or the generals taking the decision, or is it going to have this stultifying effect of making everybody thinking what will the lawyers say, which does a lot of people, lots of spheres of life, nothing to do with the military, will say, oh no, it's a dreadful thing. You're always thinking about the lawyers rather than what you want to do in any given situation.
And the sense I get in is that is there a compensation culture, for example, within the armed forces, and there's not. There really isn't. I mean, when service personnel contact me, they do.
It's to get compensation,
but they do so reluctantly. They don't. Then they're not after a quick buck. They're not after a quick windfall. They do so because they have no choice. They're being medically discharged. They need that money, as I say, in terms of mobility aids, adaptations, etc., etc. And to be honest, in the heat of battle, when a commander or a soldier's got to make a decision, I'm sure the last thing on their mind is to worry about what the lawyers have to do. I think what Lord Hope said is exactly right, in that these decisions are made for the safety of their men and to get the job done, not on the basis of what will happen when the lawyers look at this.
Jessica, you agreeing with that?
Well, yes, I am, and I think it's notable that in both the House of Commons report and the Policy Exchange report, there is no consideration at all of whether this so-called litigious environment has actually improved or had any beneficial consequences. That issue is just not even looked at. And certainly anecdotally, I've heard that the provision of equipment in Afghanistan was a lot better than in Iraq, and that things did get better as a result of the litigation. The other thing is that neither report contains any evidence of any negative consequences. So again, it's all very anecdotal, and the House of Commons report actually says someone needs to go and do some research. So there is a real lack of evidence here as to benefits versus disbenefits.
All right.
Sorry, can I just add as well? When you're talking about the levels of compensation, what we're talking about here in terms of compensation paid by the MOD is 0.1% of the MOD's budget. That's in the region of around 70 to 80 million pounds a year. So when you look at the size of the MOD budget, the compensation that's being paid out, when you consider everything in the round, is very small. And behind that is a human story in relation to what that compensation is being used for.
Well, Jonathan Morgan, what's your evidence is the other question. You're being cross-examined here in a frightening way.
I'm well aware of it. I'm absolutely surrounded here. I mean, first of all, let me agree with the final point that was made, which is the amount of compensation being paid. It is a very small fraction of the budget, and my interest in this is not to save the Ministry of Defence money at the expense of injured service personnel. Now, as for the charge that there's no evidence whatever for a deleterious effect, well, I mean, there are quotations from very senior military figures. Lieutenant General Sir Paul Newson talks about the gradual, cumulative, insidious changes in attitudes to and tolerance of error and risk. By early 2010, it was becoming clear to us that our more junior commanders were becoming increasingly risk-averse. Now, I'm not in the army, so it's difficult for me to say, but I'm not sure how we are to dismiss this as purely anecdotal when it's one of the most senior commanders in the army.
Jessica Simon, is that anecdotal? Is somebody saying we're finding this? Or what do you want to say? Quantitative analysis of decisions taking a ridge in a battlefield.
The House of Commons Select Committee says that the government needs to go out and do some proper research and actually get some evidence in. So I'm effectively basing it on that. I obviously read the Policy Exchange report, but apart from statements like that, there's no actual empirical evidence.
Well, just finally, where is all this going to go if this report isn't adopted? Human rights are developed on the battlefield. Negligence claims are brought. Taking on sometimes very ferocious foes who aren't as bound by the European Convention or other factors. Is it your suggestion, Dr. Morgan, that the army's sort of fighting its wars with its one hand tied behind his back and another hand holding onto a legal textbook? Is it really like that, or is it just some rules and regulations are being applied to what's going on?
If one is optimistic, then the best thing that might happen, if there is no legislative response to this, is that very eventually the courts will evolve a very clear set of principles showing exactly what can and what can't happen. So this is the traditional common law process. It's also how law develops in the Strasbourg Court of Human Rights, for that matter. But I fear it will take a long time to get there, and there'll be a real lack of clarity, which is damaging. So people say, well, all we need to do is to have better legal training for the armed forces so they know better what the law requires of them, and then they won't be worried about it anymore. But the less clear the law is, the harder it is to explain. I mean, I'm a lawyer, and I found it quite difficult to follow through all of the development of the Strasbourg jurisprudence. There are very long decisions of the House of Lords and the Supreme Court going through this as well, and how junior soldiers that have it explained to them, I'm not sure.
Andrew Buckham, is this a problem, you think, for serving commanders, serving soldiers to understand what their legal obligations are, or is you just come along and find when things have gone clearly wrong and bring an action?
I think there are concerns there. I think some of that, as was said before, comes down to misunderstanding. And as we've developed throughout this debate, is that the issues are not clear cut. But that's the law. And what I would say is that whatever legal framework the armed forces will have, they will operate within that, and they will do the best job they possibly can do. But it's a difficult issue. And what I would say is that looking at these particular reports is that you can't make these wide-sweeping changes that are being put forward without looking at some of the detail in relation to all of this.
Jessica Seymour.
Well, the military is already subject to a lot of much more complicated law. The military manual is a very large volume, and this is not actually very complicated law. We have very, very long judgments because the judges went through all the authorities and various analysis. But in the end, the 100-page Smith judgment just concludes, in terms of human rights, that the Human Rights Act applies overseas. So you can say it in a single line. That's all the military really needs to know. So one can exaggerate these things.
Well, they have to know what's in the Human Rights Act.
They have to know what that means,
yes.
But so do the police. So do they have to know it when they're operating within the United Kingdom. So I think this is a bit of scaremongering.
Well, I'll give the last word to the Supreme Court, to Lord Hope. Are you comfortable, Lord Hope, that you and your brother judges, your successor judges, are comfortable with taking these decisions, applying the European Convention, Human Rights Act and all the other parts of domestic law to a battlefield situation?
Well, I think we keep an open mind on these issues. You have to remember that Smith came before the Supreme Court before the evidence was led. That was one of the problems. So there's a difficulty for the appellate judge in framing a judgment in being too precise for fear of causing problems when the case comes up for trial. So one's function was to try to set out the basic principles, and they can be found, as Jessica was suggesting, in probably 2 or 3 paragraphs in the long judgment. But these principles can be re-examined, of course, as time goes on, and the common law is an evolving creature. That's how it has always worked and will continue to work.
Well, we'll have to leave it to carry on evolving. I'm afraid we've run out of time for our discussion there. The battle is over for now. Thanks to all my guests, Lord Hope of Craighead, Dr. Jonathan Morgan, Andrew Buckham and Jessica Seymour QC. Next week on Unreliable Evidence, we'll be looking at the law for motorists and the rules of the road. Until then, goodbye.
Unreliable Evidence is presented by Clive Anderson and produced by Brian King. It's an above-the-title production for BBC Radio 4.